Okay, good morning, everyone, and welcome to our update on legislative changes made to data practices laws during the 2026 legislative session. We'll spend some time highlighting some questions we've been seeing about data practices and the open meeting law as well. And so thank you for joining us this morning. As a quick reminder, the Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions, and we provide legislative assistance and training. This PowerPoint is posted on our website where you registered, and you should be able to click the link on this page to get to our website. We also record our webinars, so if you missed part of today's discussion or want to go back and watch it again or find one of our prior series, they are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. Here's our schedule for this webinar. First, we'll cover key additions and updates involving data practices laws that happened during the 2026 legislative session. After that, we'll spend some time discussing recent questions the Data Practices Office has received over the past few months. And as always, we'll leave some time at the end for a Q&A. So please feel free to send in your questions as you think of them using the Q&A panel on the screen. To get to the Q&A panel, you'll select Q&A at the top of your screen. If you don't see that as an option, you may need to click the More button, which is the 3 dots. From there, you can open the question and answer. You can also start sending in questions now, or you can wait until the end of the presentation. One added note here is that there is an option to send in your questions anonymously, which you're certainly welcome to do. But just keep in mind, if you do send your question in anonymously, we may not know who you are. And so we won't know who you are. And so we won't be able to follow up with you afterward if we don't get to your question. So just keep that in mind. If you do want to submit anonymously, completely welcome to do so, but we might not get to that question and have to follow up with you, or you'll have to follow up with us later in order to get that question answered. Okay, let's get into some of the changes the legislature made during the most recent legislative session, which includes both amendments to existing provisions as well as the creation of new requirements. As we're going through the changes, I'll cite the statutory sections that have been amended or added. If you'd like the specific citations to the session laws, I recommend looking at the newsletter my office sent earlier this month. If you do not receive our newsletter, you can sign up for it by visiting our website and selecting the subscribe to our newsletter box on the homepage. You can also find past newsletters on the news section of our website. Additionally, I won't necessarily be highlighting every change the legislature made to, to the Data Practices Act and related laws. Many changes may be specific to just a few agencies or a small number of folks who are attending this webinar. So if a bill passed directly affecting data maintained by your agency and you'd like to discuss, please feel free to contact us. But for today, I'm going to focus on changes that impact a large number of government entities. As a final note, today is July 21st, 2026, and most of these changes went into effect this past July 1st. Meaning the changes are in place now. However, I'll note any different effective dates that you need to know in order to comply with the law. Okay, the first major legislation I want to address is the creation of the Office of the Inspector General. This bill was in the works for a couple of sessions now and is part of the legislature's response to the concerns in recent years related to reports and investigations involving state program fraud. Specifically, the OIG will be an independent executive branch entity that is responsible for ensuring accountability, transparency, and integrity in the various executive branch agencies and programs. The Inspector General must be appointed by February 1st, 2027, and that process requires a Legislative Inspector General Advisory Commission to recommend candidates to the governor. The governor will then appoint an inspector general from the recommended candidates, and the appointee must be confirmed by the Minnesota Senate. The appointed inspector general will need to ensure that the office is operational by September 1st, 2027. Additionally, beginning January 1st, 2028, the Inspector General has the authority to appoint peace officers and establish a law enforcement agency within the OIG. The name of this possible agency will be the Office of the Inspector General Anti-Fraud and Waste Bureau, and it will have authority to conduct statewide investigations and arrests for offenses that are within its jurisdiction. Okay, let's get more into the specifics when it comes to the OIG and data practices, which will be in section 15E.40. The office itself is subject to the Data Practices Act, and it has authority to access data of any classification, including not public data, at another government entity. Presumably, this access will be sought through the OIG issuing subpoenas, and the language of the new law states that it is not a violation of the Data Practices Act when a government entity discloses not public data to the OIG in response to a subpoena. The OIG will also have authority to share public and not public data in specific situations, including to other entities if the dissemination will aid in a pending investigation or administrative action, to law enforcement agencies and prosecutors when the OIG believes the data are evidence of a crime, and to the Department of Human Services regarding reports of fraud or misuse involving Medicaid. The OIG must also share public and not public data with the legislative auditor upon request. Section 15E.40 also classifies any data that are related to a civil investigation the OIG is conducting as confidential data on individuals or protected non-public data not on individuals while an investigation is active. And whether a civil investigation is active is determined by the Inspector General. The civil investigation data become public upon the OIG's completion or referral of the investigation, except when the release would jeopardize another active investigation. When the OIG reasonably believes the data will be used in litigation involving civil, criminal, or administrative matters, or the data are otherwise classified. In situations when the OIG decides to no longer actively pursue a civil investigation, then data related to the civil investigation are private or non-public data. However, data relating to the investigation's general description, existence, status, and disposition, as well as data documenting the OIG's work, are public data. On a final note, the data that are collected by the Anti-Fraud and Waste Bureau, which is the law enforcement agency that the OIG may establish, are not governed under Section 15E.40. Rather, the data the Bureau maintains will be governed under Section 13.82, which applies to law enforcement data. Okay, next we're turning to some data practices involving school districts and charter schools. Section 121A.0361 requires schools to adopt a policy to implement the use of either a local or statewide anonymous threat reporting system, which is essentially a tool that can receive anonymous tips regarding dangerous, violent, threatening, harmful, or potentially harmful behavior that may occur on school property or against students and staff. Those tips may then be forwarded to school staff, the Bureau of Criminal Apprehension, or local law enforcement. School boards must adopt the policy by June 30th, 2027, and implement its policy by July 1st, 2028. I'm not going to go into all the ins and outs of the requirements for these anonymous threat reporting systems at the local or state level. However, there are some data practices considerations to keep in mind. Specifically, Subdivision 5 of this new section defines anonymous threat reporting system data as all data collected, created, received, or maintained by a local anonymous threat reporting system or the Department of Public Safety's statewide reporting system. The definition also includes any data created by schools, the Department of Education, law enforcement agencies, or non-criminal justice partners when responding to a tip or report submitted to reporting systems. As for the classifications, anonymous threat reporting system data are classified as confidential data on individuals or protected non-public data not on individuals while an anonymous threat report is active. Additionally, the active anonymous threat reporting system data may be shared among schools, the Department of Public Safety, the Department of Education, law enforcement agencies, and non-criminal justice partners. Once an anonymous threat report is inactive, the anonymous threat reporting system data from a local reporting system are governed under Section 13.32, which applies to educational data. Meanwhile, inactive anonymous threat reporting systems that are from the statewide system are governed under Section 13.82, Subdivision 7, which applies to law enforcement data. And to clarify, anonymous threat reporting system data are considered active upon the creation, collection, or receipt of the data. The reports become inactive when the school, MDE, or law enforcement agency determine that the data are no longer connected to a potential risk or threat, or 2 years after the last associated report of potential risk or threat made to the local or statewide systems. Okay, let's turn to a few other changes that the legislature made involving data practices. First up is one that law enforcement agencies should note. The legislature added language to section 122A.20, subdivision 2, that requires a police department or county sheriff's office to notify the Professional Educators Licensing and Standards Board, which is the teacher licensing board, and the Board of School Administrators, if applicable, when a teacher is criminally charged with one of the various criminal sexual offenses listed under section 122A.20 subdivision 1B, or similar offense that would require the licensee to register as a predatory offender. So law enforcement agencies should be familiar with these new reporting requirements in certain cases. The next new statutory section is section 211A.015, which was effective May 19th, 2026. This language classifies the street address contained in any campaign finance reports and statements that are filed with a county, municipality, school district, or other political subdivision as non-public data not on individuals or private data on individuals. Obviously, these private or non-public data are accessible to the data subject, but the data are also accessible to the person who filed the report or statement if it was someone other than the data subject. The other change that we wanted to highlight is in addition to the definition of judicial officials under section 480.40 subdivision 1. The legislature added the judges and employees of the Department of Employment and Economic Development's Unemployment Insurance and Paid Leave Appeals Division to the definition of judicial officials in the Judicial Safety Act. So section 13.991 now applies to these individuals, meaning that personal information, as defined by section 480.40 subdivision 1, are private data on the judges and staff. And like other judicial officials, the remedies under the Data Practices Act are available only if the judges or staff have provided the applicable judicial branch form to the entity. One other quick note here, the legislature did clarify that the Deed Unemployment Insurance and Paid Leave Appeals Division judges and employees are not judicial officials for the purposes of section 480.50. That means the protections the legislature created related to judicial officials' property records would not apply to these deed employees. I also wanted to just note here the fact that there weren't any changes to the open meeting law during the 2026 legislative session. So there aren't any new considerations that public bodies should be keeping in mind when it comes to holding open meetings. And that's really it for legislative changes, and there weren't a whole lot of new provisions for us to highlight. But again, there may be other specific statutory changes that affect a limited number of entities, and I certainly encourage you to review the statutory sections you typically work with to see whether there were other changes that may affect data you collect, create, or maintain. And again, I know one question or one concern that we often get is, hey, we want to know what these statutory sections are. Slow down with the site. Where is that information? Again, you can find these slides on our website where you registered, or you can go to our past newsletters where we also highlight the session laws where these changes occurred. So if you are looking for those specific statutory citations for any of the changes that we just discussed, it'll be there on the slides or in our past newsletter from July here in 2026. Okay, let's now turn to just a few questions that the Data Practices Office has received in the past few months that we wanted to highlight for a wider audience. Our first question is about data practices policies. If an entity has no changes they need to make to their policies, do they have to update them annually? If this question sounds familiar, it is. It's the same question that we had first in our July webinar last year because it's our reminder that August 1st is right around the corner, which is the statutory deadline for all entities subject to the Data Practices Act to update their data access policies. As a reminder, Section 13.025 of the Data Practices Act requires all government entities to create and maintain policies regarding access to public data, as well as the rights of data subjects. In other words, your entity needs to have a data access policy for members of the public and a policy describing data access and the rights of data subjects. The law also requires these policies be reviewed and updated by August 1st of each year, or at any other times as necessary to reflect changes in staffing or your procedures. Even if you think your entity needs no changes in its policies from the last year, you should still review your policies to ensure that contact information for all staff listed in the policy is accurate. Dating when your policy was last reviewed can help you track these accuracy checks and ensure compliance with the August 1st deadline. So our answer to the question is yes, check your policy annually to make sure it's up to date. Even if no changes are necessary, document the policy was reviewed to ensure compliance with these Section 13.025 requirements. If you need assistance creating a policy, our website has sample policies and a guidance worksheet to help you consider different factors as you update your policies. Visit the DPO's website and select the Resources menu to find a page with example policies. Additionally, this time of year is also a great time to see if your policies are easily accessible to the public, which is required by law. One of the easiest ways to do this is by posting the policies on your entity's website. So if your entity hasn't posted the access policies online, that is something that we definitely encourage you to do. Our next question. A local government entity contacted DPO and explained that it had been receiving several requests that appeared to be generated by AI or some type of bot. Specifically, the requests used the same stilted language, but the names were different and used slightly different email addresses to submit the request. Additionally, the requesters asked that data be sent to physical and email addresses that didn't seem to exist. The question for us was whether the entity needed to keep responding to those requests. So, as a general reminder, there's no language in the Data Practices Act that allows a government entity to determine that it will not respond to a data request on the basis that it believes the requester may have provided incorrect information in the requests. Additionally, I don't think the fact that it appears that the request may be AI generated allows your entity to deny access because those data requests often do have a human somewhere on the other end. That said, there are some practical considerations here, and it's not reasonable for an entity to keep attempting to send data to an address that it knows that it has somehow confirmed it does not exist. For example, if an entity has attempted to send the data to the provided address and the Postal Service has returned the mail as undeliverable, then it's reasonable to inform the requester that your entity has made attempts to provide access to data by sending it to the included address. You can then ask the requesters to provide an updated mailing address in order for your entity to provide access to the data. If these requesters fail to provide an updated address, then it's probably reasonable to consider those requests abandoned. Of course, an entity should offer a reasonable amount of time before it considers a request abandoned. In short, there may be ways government entities can address these types of situations without continuously sending data to addresses they know are incorrect or do not exist. However, entities will want to ensure they can demonstrate they have attempted to provide access to data and taken reasonable steps to meet their obligations under the Data Practices Act, just in case requesters raise concerns later. Another question that we've been seeing come up a little more often is related to inspection. Specifically, a data requester asks to inspect data, and during the inspection process, the requester begins taking photos of the data. So entities are wondering if they must allow requesters to make copies in this way, and if so, can the entity charge the requester copy costs? The Commissioner has issued advisory opinions stating data requesters can make their own copies of data during inspection through reasonable means, such as using a portable scanner or taking pictures with their phone. And the applicable opinions are cited on this slide. So, government entities should allow a requester to make their own copies during an inspection, and an entity cannot charge any fees. That said, there's a few exceptions to keep in mind. First, an entity is not required to allow a data requester to plug in external devices to computer systems to make copies. The Commissioner has opined that this could pose a data security risk, and entities can reasonably prohibit requesters from doing that due to their data security obligations under the Data Practices Act. Additionally, the Commissioner noted in that opinion that the legislature has not clearly indicated that it intended the public's right to data inspection to include downloading data from a government computer to a personal device. Rather, the legislature would need to update the Data Practices Act to clearly confer that right to the public, which the legislature has not done since that opinion was issued in 2002. Second, entities may prohibit requesters from making copies of data that are copyrighted by a third party. Essentially, this type of situation is a conflict between the Data Practices Act and federal copyright law, which grants creators the right to create copies and distribute their original creative works. When there's a conflict between state and federal law, the federal law will override state law due to the U.S. Constitution's supremacy clause. For example, a city might receive copyrighted blueprints from an architect as part of a permit application for a building project. In these types of situations, an entity can inform requesters that they may not make their own copies of the blueprint data due to a federal law. So this is another situation in which an entity can prohibit requesters from making their own copies. Additionally, requesters cannot make their own copies of body camera data during inspection. Essentially, data subjects are given a special right of access to the private body camera data about others during inspection under Section 13.825, Subdivision 4. Any copies of those data must be redacted. If requesters are making their own copies of unredacted body camera data via a phone recording, they would essentially be leaving the law enforcement agency with private data about other individuals. So it's reasonable that law enforcement agencies should prohibit individuals from making their own copies of body camera data to ensure it is protecting private data about others. And finally, as an evergreen reminder, Section 13.03, Subdivision 3A states that government entities may not assess a charge or require requesters to pay a fee to inspect data. Essentially, the copy cost fees exist to help government entities offset costs when making copies of data to give to a requester. So when the requester is making their own copies, the law assumes that there should not be the law assumes that there should not be the added various costs to the entity when making copies that will then be given to the requester. Okay, let's stick with copy costs for our next question. We've been seeing law enforcement agencies charging a per video fee when someone requests copies of body camera data. The agencies have told us that the fee is established by a governing body's fee schedule to suggest that they are obligated to charge that cost. Of course, there are data requesters who are disputing this per video fee. So the question for us is whether that type of per video fee is appropriate under the Data Practices Act. Okay, so it's not impossible that the cost could be $30 per video, but I will say that it's extremely likely that this large amount complies with the Data Practices Act. Let me explain. There's no language in the Data Practices Act generally, or Section 13.825 specifically, that sets a standard fee for copies of body camera data. Rather, entities are permitted to charge actual costs when making copies of electronic data, such as a video. And remember, the copy costs established under the Data Practices Act are maximum amounts an entity can charge. In other words, if your agency does charge a flat fee, such as a per video fee, it must comply with the copy cost limitations in the Data Practices Act. And your agency should be able to describe what costs are included in that rate. If your agency cannot justify those per video costs, then your agency may need to recalculate the copy cost fees it's assessing to ensure it complies with the requirements of the law. If that fee is set by a governing body and it exceeds what is permitted under the Data Practices Act, then it's probably good to have a discussion with the responsible authority to figure out how to update that fee so it complies with the law. I don't think that an entity is complying with the law if it tells requesters, we can't do anything because the fee is set by the city council. The Data Practices Act overrules any government entity policies, such as a fee schedule, that conflicts with the language of the law. Another important consideration here, just to keep in mind, most requests for body camera data are going to be submitted by data subjects, and data subject requests are governed under Section 13.04, Subdivision 3. That subdivision states that government entities may require a data requester to pay only the actual costs of making and certifying the copies. The language does not allow a government entity to charge costs related to redactions or time spent searching or retrieving data. In short, the copy costs that your agency is permitted to charge when fulfilling a body camera data request from a data subject is the costs related to making and providing copies, such as the cost of a DVD disc or flash drive. For example, if 4 body camera videos are placed on a single flash drive, then the entity can only assess the costs related to that single flash drive rather than charging per video. Any other copying fees, such as costs related to employee time to redact data or to search for and retrieve data, are not permissible under the Data Practices Act when the subject is making a request, which means the types of fees an entity can charge for copies of body camera data are going to be limited. One last side thought as we're talking about responding to requests for body camera data. As I noted earlier, most requests for body camera data come from data subjects and are governed under Section 13.04, which means that the deadline to provide access to the data is 10 business days. The Commissioner of Administration has issued advisory opinions explaining that the language of Section 13.04 does not offer any exceptions or processes for an entity to extend that 10 business day deadline. Our office recognizes that it's likely difficult for most law enforcement agencies to provide a copy of redacted body camera data within this short timeline, but we do encourage you to work toward providing access as best you can within that deadline, such as providing access on a rolling basis and prioritizing body camera data requests. Practically speaking, the legislature would need to amend the Data Practices Act to give entities more flexibility when it comes to the time in which an agency must respond to requests for body camera data, or to permit a higher standard per video fee across the board. Okay, our next question is also law enforcement related. An agency received a request for data related to an incident involving vulnerable adult maltreatment, which the agency learned of via a report from the Minnesota Adult Abuse Reporting Center, also known as MARC. For context, MARC is operated by the Department of Human Services, and it's the central reporting location when someone believes a vulnerable adult is being neglected, mistreated, exploited, or otherwise abused. MARC then coordinates with appropriate agencies across the state to investigate these reports. Law enforcement agencies are often notified of these reports, and the question is whether the agency must include documentation and other data related to the MARC report when responding to a data request. All right, the short answer to this question is one that you've heard before. It depends. Specifically, any government data that are maintained by the Common Entry Point managed by MARC are classified as confidential under 626.557, subdivision 12B, paragraph A. So if staff have access to the Common Entry Point, I don't think they should be logging into that system for the sole purpose of downloading data or other reports as part of the response to a data request. Technically, the law enforcement agency isn't maintaining these reports in their own data systems, and there's no requirement in the Data Practices Act to go out and collect data in order to respond to a data request. However, if officers are appending these reports or copying and pasting data from the reports into the agency's investigative files, then your agency would be maintaining a copy of the data. As a result, those portions of the MARC reports could be responsive to a data request and may need to be provided. As a reminder, Section 13.82, Subdivision 10 classifies data identifying a victim of vulnerable adult maltreatment, as well as the reporter of maltreatment, as private data. Meanwhile, Subdivision 11 classifies inactive investigative data related to alleged vulnerable adult maltreatment by a caregiver or facility as private data when the investigation becomes inactive due to an agency's decision to no longer pursue the case or when the statute of limitations is reached. So, in these types of situations, the public wouldn't be able to access data related to the MARC report, but subjects of the report may be able to access the data. Of course, if the case becomes inactive because someone is convicted of vulnerable adult maltreatment, then much of the investigative data, including the portions of the MARC report contained in the investigative file, would become public once the person has exhausted any direct appeals. So there's a real likelihood that portions of the MARC report could become public when an agency is maintaining its own copies of that report. But again, as a reminder, the identities of the reporter and victim would remain private, and you need to redact those data if the requester was a member of the public and there was a conviction related to that incident. Practically speaking, it's probably worthwhile for agencies to be thoughtful about what it maintains as part of its investigative data. Obviously, the DPO team doesn't have the day-to-day experience of conducting criminal investigations, and we're not in the best position to offer guidance about what agencies should or shouldn't maintain as part of those investigations. Rather, it's just a reminder of the practical outcomes that can occur with law enforcement data, and it's probably good to be thinking ahead about these outcomes rather than being caught flat-footed about what to do when the inevitable data request arrives. Okay, our next question involves email exchanges between the members of a planning commission and a tech company that applied for permits related to a data center it was planning. The question that we addressed was whether email exchanges could be classified as private correspondence under Section 13.601, Subdivision 2. As a reminder, Section 13.601 classifies correspondence between individuals and elected officials as private data, but the correspondence may be made public by either the sender or the recipient. So, Section 13.601, Subdivision 2 would not classify these emails as private for two reasons. First, I suspect that members of a planning commission are going to be appointed officials in most situations rather than elected officials. To reiterate, Section 13.601, Subdivision 2 applies only to correspondence between individuals and elected officials. So any emails or similar correspondence that is sent to appointed officials, entity staff, or other officials who are not elected would not be classified as private data under Section 13.601. Second, this language does not apply when the individual sending correspondence to elected officials is representing an organization, such as a business. In past opinions, the Commissioner has noted that the definition of individual applies to living human beings. So, when a person is corresponding with elected officials on behalf of an organization, that person is really acting as the agent of the organization, which is not an individual by the plain language of the definition in the law. So the private classification of 13.601, Subdivision 2, does not extend to correspondence between elected officials and organizations or the organization's representatives. Therefore, the emails in this situation between the appointed commission members and company representatives are presumptively public unless a different statutory section would classify the content of the emails as not public. Okay, one last question here, and it's an open meeting law one. Specifically, a public body explained that it was holding a meeting where the last item on the agenda was an evaluation of the performance of an individual subject to its authority, which means it was closing the meeting under Section 13D.05, Subdivision 3A. Given the fact that there would be no additional public business conducted after this part of the meeting, the public body was wondering whether it could adjourn a meeting while in the closed session. So The open meeting law is silent on whether a public body can adjourn a meeting in closed session. However, the commissioner's past guidance is that a public body should probably reconvene in open session to adjourn so that the public knows when the meeting has ended. For example, the commissioner wrote in advisory opinion 12-008 that, quote, although the open meeting law is silent on whether a public body may adjourn a meeting in closed session, it is the commissioner's opinion that meetings should be adjourned or otherwise concluded in open session. Otherwise, the public cannot know if a meeting is adjourned, recessed, or continued. Whether or not a meeting has been adjourned rather than recessed or continued has implication for a public body's conduct at subsequent meetings, end quote. Additionally, the Minnesota Supreme Court has said that the open meeting law should always be interpreted in favor of transparency. As a result, it's important to make the more transparent decision anytime there might be a little bit of confusion over what a public body ought to do. Here, the meeting would be closed under Section 13D.05, Subdivision 3A, which meant the board needed to summarize its conclusions regarding the evaluations of the executive director at its next open meeting. So, reconvening in open session to adjourn the meeting, even if no one is present and considering that the process can be a bit administratively cumbersome for the board, is probably the safest approach. So, those were our questions for today, and now it's time to hear your questions. We've got a little bit of time for that. So please submit your questions in the Q&A panel. Again, to get to the Q&A panel, you'll select Q&A at the top of your screen. If you don't see that as an option, you may need to click the More button, which is the 3 dots. From there, you can open the question and answer panel. If we don't get to your question, we will follow up afterwards. But remember, if you submit your question anonymously, we aren't able to follow up with you because we won't know who you are. So you do need to reach out to us, and you can do that at info.dpo@state.mn.us. And as the other folks are getting ready to answer questions here, just a reminder, the slide deck is available on our website at the link here. Scroll all the way down, and they are under the toggle for other data practices and open meeting law guidance webinars. And you can access the recording on our YouTube page in the next day or so. I'll also be putting the evaluation in the Q&A panel here shortly. If you would like to please fill that out and let us know how we did, what other topics you'd like to see in the future, that would really help us out. And so I will turn it over to the Q&A now.
All right. This is Grace with Data Practices Office. So our first question says, for body-worn camera costs, what about the physical computer and computer software used to create copies of the BWC? Can those be taken into account with costs? So the commissioner has issued quite a few advisory opinions about copy costs and has opined that it's not appropriate for a government entity to charge for wear and tear or depreciation of equipment that makes copies. So I think that those opinions could apply to the physical computer itself. The entity has to have that computer to do their work, but they can't pass along those wear and tear or depreciation charges as part of copy costs. For the computer software, I think it gets a little tricky on how you would break up those costs, because I assume that a lot of the use of the computer software is in order to redact that data. And as you know, you cannot charge for the time spent on redaction or like costs related to separating private from public data. Or in the case of body-worn camera, private data on someone else from private data on the data subject. So I'm not sure how you would break up those computer software costs to just account for making the copy. And then also looking at breaking up those costs, right? Are you paying a yearly fee for the computer software and then you're dividing it by the number of data requests you get? I just think it could get pretty complicated, but there might be a way that you could take into account some of those software costs. But I do think it would be kind of hard to break those up.
All right, this is Taya. I'm taking 2 questions. One is a question about policy updates that you should review and do by August 1. And the question is whether or not they need to be submitted to the Data Practices Office or reapproved by August 1, even if no changes. So you never need to send your policies to us. If your entity has adopted the model policy on our website, there is a notice that you send to us just to let us know that you've done that. But if you have no changes, it's helpful to, on the policy, just say reviewed and then put the date so that you have documented in some way that you have reviewed the policies. And even if there's no changes, you've documented that you've done it for the year. So no need to send them to us, but some documentation is helpful even if there's no changes at this time. The other question is about whether we have an update on the timing for updating the administrative rules in Chapter 1205. And that project is on hold a little bit. We have been understaffed. We are currently at full staff, which is exciting. And so right now that project has been on hold for quite a while. We're hoping to give it more attention in the coming fiscal year. So we'll try to move that one forward, but it has been on hold, and that's why you haven't heard anything for a while.
Okay, I'm just going to hop in here to let folks know that I dropped the link in the Q&A and the chat, the discussion panel for filling out the webinar evaluation. You can also click on the link on this slide here and let us know what topics you think we should cover in the future, as well as any suggestions for making webinars more effective. We definitely review all of your comments, and that would be helpful. And while I'm off mute here, I'm happy to hop in with just answering a quick question. We had a data request inquiring about certificates of insurance collected by the city for vendor contracting services. Would this be considered public data? Short answer, probably. I can't think of anything in the Data Practices Act that generally classifies these data as not public. As a reminder, data are presumptively public. And so, yeah, those sorts of things that would maybe be submitted as part of that contracting services or vendor services that you need to collect, it's probably presumptively public unless there's really specific information in there, like a social security number or things like that. Then, there may be portions that need to be redacted if it does include those types of things. But yeah, as a starting point, that data is probably going to be public.
All right, we have a question here about if there's guidance on charging actual costs for providing electronic files such as PDF or other document types. The charge would be for search and retrieval of various electronically saved files and not redacting. Yeah, so for requests for public data, you can charge for that search and retrieval time. What that cost will be depends on the employee at your entity who's doing that search and retrieval. You would need to track their time, and then it's based off of what they're paid. So the copy cost is actually the employee time to search and retrieve that data. The commissioner has said that it needs to be the lowest paid entity employee who could complete the task. That doesn't mean that it needs to be the lowest paid employee at the entire entity. It's really who is able to search and retrieve that data and complete the task. So not everybody will have access to all of the files they need to search and retrieve. So for instance, like someone at the Department of Administration might not have access to Data Practices Office files. So it would be someone within the Data Practices Office who's searching and retrieving that data. But you'd be charging the time for the person who's doing that search and retrieval. The lowest paid entity employee analysis is really meant to get at, if there's like a chief of police, he doesn't need to be searching and retrieving for those files or that data. Someone else in the entity would be able to respond to that data request.
All right, we are at time at this point, so we'll pause there. If we didn't get to your question, we will follow up with you and certainly answer that. And so we've got, I think, everybody's questions here. I do see names on. And so, yeah, you can look forward to someone from the Data Practices Office following up with you and offering a little bit of further guidance on those questions. But that is our time for today. Thank you again for your attention and sending in your questions, and we will look forward to speaking with you soon. Thanks.